My name is Jeff Morgan. I'm from Dallas, Texas. I'm going to give my opinion on Section 153.312 of the Texas Family Code, parents who reside 100 miles or less apart. And this question has come up due to the recent COVID-19, otherwise known as the coronavirus incident, and the extension of spring breaks in our school systems. Now, according to the Texas Family Code, it says this: in 153.312, parents who reside 100 miles or less apart. A, if the possessory conservator resides 100 miles or less from the primary residence of the child, the possessory conservator shall have the right to the possession of the child as follows. Going down to the pertinent part with the COVID-19 virus, down to letter B, it says the following provisions govern possession of the child for vacations and certain specific holidays and supersede conflicting weekend or Thursday periods of possession. The possessory conservator and the managing conservator shall have the rights of possession of the child as follows. And number one, it says this: the possessory conservator shall have possession in even numbered years, beginning at 6 p.m. on the day the child is dismissed from school for the school's spring vacation and ending at 6 p.m. on the day before school resumes after that vacation. And the managing conservator shall have the possession for the same period in the odd number years. Now, I think it's important at the beginning to give the disclaimer that I'm neither a family law attorney nor am I a district court judge or a family law judge, but I can read plain English. And the plain English says this: that beginning at 6 p.m. on the day the child is dismissed from school for the school spring vacation and ending at 6 p.m. on the day before school resumes after that vacation. That seems to be pretty plain and clear, and most people would think that. However, these family court judges have decided they're going to collude together and come up with their own opinion. Now, I think this is illegal as can be what they are doing. I believe that they are responsible for collusion. Most of these judges will tell you, well, we have to obey the Texas Family Code. We must obey the Texas Family Code. And yet now they are going to reinterpret the Texas Family Code according to their wishes so that they don't have cases coming in front of them. About a month and a half ago or two, I was at a forum in which some people who were running for judges were talking about this issue, about what type of about whether constitutional rights are valid in family courts. And the judges were saying, well, we really can't think of any type of a situation where the Constitution would be in conflict with the Texas Family Code or with the rights of the court. But one candidate for judge said this: without a specific set of facts, it's very hard to respond. A second candidate said, it's also really hard to respond because it might be something that if it come before the court, we couldn't elicit a response to about. If it were something that could come before the court, we really can't answer that because that's not something you're allowed to do when you sit on the bench having a predisposition about it. And a third judge candidate said, we really can't speak without a specific, we really can't speak as to how we would rule.
As a judge, if you were presented with a case that violated constitutional protections of one of the parents, is that what we're asking?
Parties. One of the parties, yes.
Of one of the parties.
And without a specific set of facts, it's very hard to respond.
It's also really hard to respond because it may be something that comes, if it comes before the court, that we couldn't elicit a response to about if it were something that could come before the court. We can't really answer that because that's not something that you're allowed to do before you sit on the bench and predisposition about it.
I agree with Melvin. We can't really speak without a specific. We can't speak as how we would rule.
So these are three individuals running for a judicial position to become judge in their district that they're running for, and they acknowledge, every single one of them acknowledge, they can't talk about a hypothetical case. They can't make a supposed ruling because that would be a predisposition on a hearing. And I would think that at that point, once they have a predisposition, they should be recused from hearing the case. And yet today, as we look at what's taking place in the state of Texas, we have many, many judges who have predisposed themselves, who have made a ruling without an actual case before them, who have ruled on a hypothetical that I think completely violates what they are allowed to do as judges. In fact, I think every single one of these judges should be reported to the State Commission on Judicial Conduct for what they have done. And I think that some of the judges should get up and apologize immediately, and I think that any case that they hear regarding child possession, they should be recused from, because they have predisposed themselves to making a judgment of a case that has not even appeared before them. The judges are trying to stop one parent from exercising a legitimate right according to the Texas Family Code, their Bible that they worship. And yet here's what these judges are saying. K. Denise Garcia on March 13th wrote this: 7 out of 7 Dallas County Family Court District judges agree that the standard possession schedule follows the originally published school calendar. And in parentheses, she says, no extensions of time periods due solely to recent changes. Now, I did not read that in the Texas Family Code. Somehow these judges, who evidently know all and are able to, once they put on their cloak, their robe and everything else, and they act in a judicial capacity, they almost speak ex cathedra as if they somehow know and can interpret the mindset of the Texas Family Code. 7 out of 7 judges got together. To me, it sounds like it was collusion. It sounds like these judges are saying, what are we going to do? Let's talk about our plan of action. They have not heard an actual case, but they are predisposing themselves. They are basically ruling against a parent who would say, wait a minute, the Texas Family Code says this, I'm allowed to keep my children until the day before school resumes during spring break, and the judges are trying to shut this down. Many of these judges, I am sure, would claim that they are not judicial activists. No. But they are opining on a decision, on a case that has not even appeared before them. They are opining on a hypothetical. They are predisposing themselves, and I believe should be recused henceforth from any hearing regarding child possession. Now, we also have Judge Jerome Hennigan, and he is talking about the policies of the 231st, 233rd, 322nd, 324th, and 325th District Courts as to the cancellation of dockets due to the coronavirus. The pertinent paragraph is this: it is also the policy of the above courts that though some school districts are, quote, extending spring breaks because of COVID-19, spring break possession ends according to the previously scheduled spring break as set forth in the school calendar for the applicable school district. Now, where is this in the Texas Family Code? Did somehow this judge rewrite the Texas Family Code on his own and just put this in here? So he's issuing his opinion about what should be in there, but what's not in there. And again, I'm sure this is one of these judges who would say, well, I must follow the Texas Family Code. But here he is rewriting the Texas Family Code and opining on a case, predisposing himself to an opinion on a hypothetical case that has not yet come before him. He has not heard any set of facts, but he's telling everybody, he's signaling that how he is going to rule. He is trying to stop a parent from exercising his or her right during this time of the spring break. And in order to show that there wasn't complete collusion in this whole thing, he's added this little tidbit. Even though Judge Bennett's policy will differ from those set above, Judge Bennett does agree with the policy of the other district courts as to spring break possession periods. It is our understanding Judge Bennett will issue her own orders regarding her dockets as to all other issues. So this is signed by Judge Jesse Navarez, by Judge Jerome Hennigan, by Judge Judith Wells, and by Judge James Mumford. Judge Kenneth Newell did not sign this. I'm not sure why, if they just didn't get to him, but I do have right here 4 judges evidently that have gotten together and have decided this is going to be their policy. And once again, I ask, where is this in the Texas Family Code? Is this not a predisposition on how they are going to rule in a case that has not even appeared before them? Without any set of facts, they are issuing a ruling. And this goes against any type of fairness and due process in a judicial hearing. The Tarrant County 360th Family Court sent this: it is ordered that spring break shall end as published in the school calendar before COVID-19 policies. Now, isn't this amazing? Because here it is a judge. Now, maybe this judge thinks that he's some type of a great judge that can determine what immigration policies are going to be for the entire United States. No, he's not going to go quite that far. But he's going to say, it is ordered. I am going to declare that my policy is going to say that regarding spring break, the spring break shall end as published in the school calendar before the COVID-19 policies. Again, there is no case set before him. There are no sets of facts. But this judge is making a decision based on a hypothetical. He's issuing policy. He's making a statement. Again, is this the role of a judge? I thought the role of a judge was to hear a case and to exercise judicial discretion. This is a bunch of crap what he is doing. It is ordered, according to the 360th Family District Court in Tarrant County, it is ordered that if a child is to be returned on Monday after spring break, which is not in the Texas Family Code, their Tarrant County 360th Family Court. I can't read English, and I didn't say that. It just says ending at 6 p.m. on the day before school resumes after that vacation. So, I mean, you're even misreading the Texas Family Code here. It is ordered that if a child is to be returned on Monday after spring break, there is no Monday even mentioned in the Texas Family Code. But he's putting this word in there to maybe give himself an appearance of legitimacy. He is acting once again against any judicial restraint that he should be acting. He's ruling on a hypothetical. He's predisposing himself. He should be recused from any future case pertaining to child custody matters, in my opinion. It is ordered that if a child is to be returned on Monday after spring break, the child shall be returned at 8 a.m. on the date school was to resume after spring break, pursuant to the calendar published by the school before COVID-19 changes. It is ordered that if the child was to be returned Sunday at 6 p.m., then the child shall be returned Sunday at 6 p.m. before the school was to resume from spring break pursuant to the calendar published by the school before the COVID-19 changes. Now, once again, where in the Texas Family Code does it say any of this stuff? This judge is making up his own rules, making up his own laws, rewriting the Texas Family Code from the bench or in collusion with others. I don't know. Now, I'm sure that this judge would tell you that he must follow the Texas Family Code, and yet right now he is rewriting and changing the Texas Family Code to suit his own dictates. This judge, again, should be publicly reprimanded by the State Commission on Judicial Conduct. In fact, I would go so far as to say the legislature should convene and reprimand all of these judges. And I will tell you right up front, some of these judges I know personally. I like some of these judges. Nevertheless, what they have done is strictly against their duties, and they should be reprimanded. Now, I've talked about Dallas, I've talked about Tarrant County, but here's the one that I really like. This is coming from Galveston County, and this was issued March 16th, 2020. For parents who have not returned children by Monday, March 16th, you must, and this is in all caps, you can see it right here, I'll have it down, you must return the child immediately or you will be found in contempt of court and will be fined and sanctioned. Now, this is illegal as can be what they are doing. They are threatening from the bench. They are threatening. There is no order pertaining to this. They're making up an order right now. This is a standing order and notice to all Galveston County families with court orders regarding visitation for spring break. They are making this stuff up on the fly. These judges who are colluding together illegally, and they are issuing an order, any party found willingly violating this court order will be found in contempt of court and will be dealt with accordingly. Now, this is a threat. This is a threat by these judges. There are 4 judges listed down here. This is signed by Judge Ann B. Daring, D-A-R-R-I-N-G, by Judge John Grady, by Judge Carrie Foley, F-O-L-E-Y, and by Judge Jack D. Ewing. If you do not do this, even though there is a very strong reason that the parents can say, wait a minute, according to the Texas Family Code, which I am following, and you, by the way, Judge, are reinterpreting and are not following, you are stating before even hearing any facts that you will find me in contempt and sanction me accordingly. These 4 judges need to be publicly reprimanded and perhaps even removed from their position. They should be recused from all further case pertaining to issues of child possession. Now then we go down to El Paso, because this is not just up north here and in Dallas and Tarrant County. It's not just Galveston County. We go all the way over to El Paso. And here is Judge Laura Strathaman, the Texas 388th District Court of El Paso, Texas. And An El Paso judge has determined when spring break visitation expires for divorced and separated families.
My name is Judge Laura Strathman, and on behalf of all of the family court judges of El Paso County, Texas, we hope that this message finds you and your family in good health. The family court judges of El Paso County, Texas understand that the families are experiencing some confusion related to the COVID-19 virus and the extended closures of schools as it relates to the spring break holiday. As a result, the El Paso family courts have taken the following position. The spring break holiday or spring break intercession ends on March 22nd, 6 o'clock p.m. Children who have visited over the spring break period shall be returned to their custodial parent on March 22nd at 6 o'clock p.m.
Here's another judge. This judge evidently just thinks that somehow she has all of this wisdom that has come to her, and somehow she's able to determine when exactly spring break visitation expires for divorced and separated family. Judge Laura Stratham's office sent a news release to share the court's stance. The court's stance, without having heard any facts, she is stating right now she has a predisposition that she is going to rule against parents who violate her stance. This is not law. Her stance is not law. Her stance is not Texas Family Code. Her stance is her stance. She also is not objective in this matter, and she should be recused from any further hearings regarding child possession. Judge Laura Stratham's office sent a news release to share, how kind. She's going to share the court stance. It's an illegal court stance, but she's going to share the court stance on how long spring break visitation will last since the school districts recently extended spring break until April the 6th. Now, it says right here, the spring break has been extended until April the 6th, but the judge has decided that she has seen things differently. Her stance, her viewpoint, which she wants to now make evidently the law, says this. The judge ruled, was there a case in front of her that she made this ruling, or did she just rule ex cathedra from her judicial throne? I don't know. And I would like to have some more details about this. But Judge Laura Stratham of the Texas 388th District Court in El Paso, Texas, has ruled that children that are subject to a possession order that include a spring break or spring intercession visitation must be returned by 6 p.m. on March 22nd. Now, this is a judicial activist, obviously. She's trying to claim that she is the law. She's trying to rewrite the law. I don't know what she's trying to do, but she's not acting as a judge. There's no case in front of her. But she also says that in her writing that closure of schools will not extend the spring break possession period, Stratham wrote. Where does she get the authority to interpret this? This judge, in my opinion, needs to be publicly reprimanded by the State Commission on Judicial Conduct. And there are other articles that have been written about this. If you look at the Collin County District Court, some school districts are talking about extending spring break, but we believe a standard possession order under the Texas Family Code follows the originally published school calendar. We believe. So is we believe now the new law? We believe that the Texas Family Code should be rewritten, so we as judges are going to rewrite the Texas Family Code. And now the Texas Family Code is unconstitutional in many aspects to begin with. It is a mess, a hot mess of contradictions and everything else. But nevertheless, this is the Texas Family Code that they say they must obey. But none of the Collin County District Courts we believe that a standard possession order under the Texas Family Code, which we are now reinterpreting, follows the originally published school calendar. Is there any precedent in law? Where are they coming up with this stuff? This is an extraordinary event that has taken place, but now these judges are going to predispose themselves in a ruling. They should all be recused from any type of these hearings whatsoever, and I also believe that they should be publicly reprimanded by the State Commission on Judicial Conduct. Going to Denton. Now, Denton County District judges take the position that any school district's additional school closure following the week of spring break, whether the district calls it an extension of spring break or not. So now here is the judges are colluding together. Once again, this is judicial collusion, and they're going to say, well, oh, wait a minute. They've said it was an extension of spring break. Now we're going to reinterpret what the school district said. We're going to tell the school district, you used the wrong language. Now, again, these judges, they somehow, I guess, in their by virtue of who they are, they get to just make up laws as they go. They get to reinterpret things. I mean, maybe we should go to the judges and say, Judge, could you please tell us what the latest news is? Because obviously you have the prerogative of reinterpreting everything. The Denton County District judges take the position that any school district's additional school closures following the week of spring break, whether the district calls it an extension of spring break or not, does not extend a parent's period of possession beyond the week designated for spring break according to the school's academic calendar and the possession scheduled in the final order. Well, the final order does not say that, does it? Judge Sherry L. Shipman, presiding judge of the 16th District Court in Denton County. The final order does not say this, but now she's going to opine on what it should have said. Sorry, but that's not what it does say, and you know that you are making the stuff up as you go. I also believe that Judge Sherry L. Shipman should be recused from hearing any further cases about this because she has predisposed herself as to the way that she would rule. And once again, I also believe that the State Commission on Judicial Conduct should publicly rebuke her and the other judges that colluded with her on this policy. Now to go to Rockwall County, and I'm very familiar with Rockwall. I used to live in Rockwall. The 382nd District Court, which with Judge Brett Hall, and I've got plenty of things I can say about Judge Brett Hall, and also the 439th District Court with Judge David Rackow. And the only time I've been in David Rackow's court, I actually liked what I saw, but I've also heard some other things too, so I'm not going to speak about hearsay, but there may be some issues there. Nevertheless, these two judges in Rockwall County, Judge Brett Hall and Judge David Rackow, have said to all attorneys and or parents, it is the court's policy to follow the originally published school calendar regarding access and possession of children during spring break for the purposes of interpretation and enforcement of court orders. Once again, these judges are making policy as they go. They did not write this into the orders. It does not exist. And they are predisposing themselves as to how they would act. So Judge Brett Hall and Judge David Rackow should be recused from any case in the future pertaining to issues of child custody, and I believe they too should be publicly reprimanded by the State Commission on Judicial Conduct. Now we also have Lovejoy School District, and Lovejoy School District wrote this: Dear Lovejoy families, we want to extend our thanks to our amazing Lovejoy community for the concern and care that you've shown during the rapidly changing circumstances surrounding COVID-19. Lovejoy ISD remains committed to providing outstanding education in a safe and secure learning environment while keeping students at the heart of all of our discussions. Due to the March 11, 2020 announcement by the World Health Organization that the outbreak of the new coronavirus has been declared a pandemic, updated announcements by the Centers for Disease Control and information from medical professionals and state and federal health officials, the following action is being taken in an attempt to minimize health and safety risks to our Lovejoy community. The action is this: as a precaution, Lovejoy ISD is extending spring break by 1 week. Lovejoy ISD is extending spring break. This is what they wrote. Now, according to the Texas Family Code, the possessory conservator shall have possession in even-numbered years. 2020 is an even-numbered year, beginning at 6 p.m. on the day the child is dismissed from school for the school's spring vacation and ending at 6 p.m. on the day before school resumes. On the day before school resumes after that vacation. Now, Lovejoy says, as a precaution, Lovejoy ISD is extending spring break by 1 week. And the Texas Family Code says that the possessory conservator shall have the child ending at 6 p.m. on the day before school resumes after that vacation. Now, that is very, very clear. And in fact, I even have an order that one person sent me. It says this: spring vacation by Mr. So-and-so in even-numbered years, beginning at the time the child's school is dismissed for the spring vacation and ending at the time school begins on the day school resumes after that vacation. all of these judges that are getting together and interpreting or reinterpreting the Texas Family Code, in my opinion, need to be publicly rebuked by the State Commission on Judicial Conduct. They have predisposed themselves to what they are going to say. In addition to being publicly rebuked, perhaps they need to be fined. Perhaps they need to step down. Perhaps they need to be recused from every single case pertaining to child custody matters in the future. And now you might just think, well, Jeff, you're not an attorney. You don't know what you're doing, what you're talking about. Yes, you can read English. Okay, the English is plain and clear, but you know, the attorneys, they have legalese. They have special ways that they interpret this stuff. Well, it just so happens that I do have an opinion by an attorney who says this. How can the court clarify under the rules? The language is pretty plain. It says the day before school resumes. That is not vague or ambiguous. It does not account for national disasters or emergencies, but it is not unclear. It is not unclear. Now, these judges, all these judges that have colluded together to reinterpret the Texas Family Code, somehow they have tried to think, maybe it is vague, maybe it's ambiguous, maybe we need to reinterpret the obvious. Sorry, judges, it is not vague, nor is it ambiguous. Yes, it does not account for national disasters or emergencies, but it is not clear. There is absolutely no way that a judge could sign a habeas or hold someone in contempt for keeping the kid based on the plain reading of the order. These judges are acting in an activist manner. These judges are acting in an unconstitutional manner. Every one of these judges needs to, again, be publicly rebuked. I almost think that they should be removed from the bench. That's how bad their collusion is in this matter. In fact, I also think that perhaps maybe even the FBI should be coming in to investigate this matter, because what you have right here is a deprivation of rights under the color of law. That is a federal crime. For every one of these judges that have signed such an order or said that this is our policy, I believe that you are guilty of the deprivation of rights under the color of law, which is a federal crime. And I do believe that there may be some people speaking with the FBI about this right now, and I fully support them in their efforts. If these judges have done this, if they have deprived people of rights under the color of law, they need to be investigated and they need to be held accountable. There is absolutely no way that a judge could sign a habeas or hold someone in contempt for keeping the kid based on the plain reading of the order. We all wanted to say the day before school regularly resumes, but it does not. It does not. These judges are reinserting language. They're reinterpreting language. These judges are making their own decisions. They are not following the Texas Family Code, which, as I said, I think it's an unconstitutional morass of contradictions. But nevertheless, this is what they say. We must obey the Texas Family Code. They have no right to reinterpret it. They have no right to do any of this stuff, but they are doing it. That being said, there are lots of things that the judge could do to the non-custodial parent that do not involve contempt or the threat of contempt or the threat of some other things, as took place down in Galveston County, for not returning the kids if they are playing games here. They're not playing games. They're following the order, and they're following the Texas Family Code. Why do we say that they're playing games? They're following the order. They are allowed to do this according to the order. The technically correct thing isn't always the right thing. Well, that's fine. There's nothing wrong with that. The technically correct thing is not always the right thing to do. However, the technically correct thing for these judges to do is to follow the law, not to reinterpret the law, not to impose policy on people, not to collude together and to predispose themselves to how they will rule. Once again, I believe this is a deprivation of rights under the color of law that should be investigated by the FBI, every single one of these judges. And I'm sorry, some of my friends are included in this. I believe that you too should be investigated because of what I believe is a deprivation of rights under the color of law. And in saying all of this stuff, I am not for non-custodial parents and I'm not against custodial parents or the other way around. What I'm saying is this: the state itself has caused these problems. The state in the Texas Family Code, which again I say is an unconstitutional morass of contradictions, has caused some of these problems. And perhaps the state should be held accountable. And these judges and these these so-called family law attorneys, these kind family law attorneys that talk about parents getting along, they know that they've raped parents financially. They know that they've caused problems. They know that they've inflamed situations. They've known that they've plundered children's bank accounts. They know that they have done a lot of unconstitutional things, unjust things against parents, against children, against grandparents, against grandchildren. They know this without a shadow of a doubt. And for any parent who has been influenced or affected by any one of these judges, I encourage you to file a complaint against the judge with the State Commission on Judicial Conduct. In fact, I might even do a video on how to do that. It's very easy to do. These judges need to be put on notice. What they have done is completely outside of their authority, and the State Commission on Judicial Conduct needs to investigate them. Now, I grant you that by and large, the State Commission on Judicial Conduct does very little. They're a body that primarily exists in name only. They don't really do that much, but nevertheless, you must register your complaint. And I would say at the same time, as you register your complaint, send a copy of the complaint to the Attorney General, send a copy of the complaint to the Governor, send a copy of the complaint to the media, send a copy of the complaint to your friends. Go ahead and post it on Facebook. Let everybody know that these judges are acting without any constitutional authority and that they need to be held accountable. And that's all I have to say about this matter. Thank you.